Welcome to episode 1 of our criminal law podcast. My name is Darlene and I'm here with Mr. Manyara, who's going to introduce himself and tell us what he does. Then we'll have a brief Q&A session about what defense is. Yeah.
Good afternoon. My name is Manyara Michael Mainya. I am an advocate of the High Court of Kenya. I've been admitted for 7 years now. I was admitted in 2016. I work with Karuru Maura and Company Advocates. I believe that is my background, and professionally that is. If can proceed with any questions you have.
Right. So basically, exactly what do you do?
Okay. First, I'm an advocate, but I'm also a trained mediator and also an arbitrator. In advocacy, I have a bias to litigation, both criminal and civil.
Right. So what does civil and criminal litigation entail?
Criminal litigation is all about prosecution of crimes under the penal code and any other offenses that have been created under the law. But civil matters are private matters between the public or private entities, where they are either complaining about or they have disputes regarding breach of contract, torts, and all that. But criminal is an area of actually prosecution of crime, and this is done by the state.
Okay, that's that's quite interesting. Is there like a case or something that stood out to you, especially a criminal case? Have you ever dealt with a criminal case?
Yes, I have a bias towards civil matters, but once in a while I do attend criminal matters. And just recently I was in court doing a defilement case on behalf of a client or the accused.
So it's ongoing?
Yeah, it's ongoing.
Okay. That's quite interesting. So we were studying defenses, and again, thank you so much for coming.
Thank you for having me too.
Right. So we came up with a couple of questions while we were studying, and one of the questions that was presented was what exactly is the difference between bona fide, claim of right, color of right, and mistake of fact?
Bona fide literally means good faith, in that maybe you have committed a crime out of good faith belief that you are not committing a crime. Like for example, if I may use the example of maybe you are being accused of car theft, but to your knowledge, at the time you were taking the car, you assumed or you rather believe that the owner had actually given you the consent or authority to use the car. That is bona fide. And the mistake of fact is that yes, you have committed a crime, but you were misled or you misapprehended some facts that led you to commit that crime. Now, this is not the best of examples, but for like a crime of rape, there is a place where maybe you may infer consent from the action of the party who is accusing you. So that could be contemplated or assumed as mistake of fact.
Right.
So that you are now able to explain that maybe I was mistaken in my thinking that if it's a gentleman or a lady, they have given consent for us to proceed in whatever act that happened, but maybe that was not the case from the other party.
Okay.
Yes.
So basically, like a misunderstanding that happened, or?
Yes. However, now it is on the accused person. The misunderstanding is only on the accused person. So that is why he has to explain himself and offer maybe the context under which the crime happened, so that it can be seen as maybe there was being misled into doing something that was not supposed to be done, and such like.
Okay.
Yes.
Another question that came up during our reading was to do with compulsion, which is one of the defenses. So basically, during the readings, we saw that there's a really slim line between what can and cannot be inferred. We saw that in compulsion, for example, you can say that someone is threatened with violence, bodily harm, instant death, but then you can't say that future injury amounts to compulsion. So exactly what's happening there?
Okay, for compulsion, or maybe you can call it coercion or duress, the danger you are facing must be imminent, in that it is instant.
Right.
If the danger is in future, then you cannot claim coercion, because now you are saying at that particular moment you had no choice. You either acted in that particular way so that you committed the crime, or it was you who was to either suffer some pain or some injury. So it has to be immediately. You cannot be threatened for a future act, because now you will be asked, you had a choice, either to report to the police or actually to avoid doing the act entirely. So that if, for example, you are threatened, somebody writes you a message that do ABCD or ABCD will happen. First, that person is not with you and is threatening something that will happen in the future. So if you go ahead and do it, you cannot claim compulsion. But assuming, right as we are sitting currently, I put a gun on your head and tell you, if you don't stab him, I will shoot you. Now, if you stab him, yes, you have committed a grievous bodily harm to him. However, it was under compulsion, in that you will accept that, yes, indeed, what I committed was an act of violence against him, but I had extraneous circumstances leading me to it. Then now you will bring the defense of compulsion and it will be accepted.
Right.
Yes.
Okay, that makes sense. During reading also, I saw that there are some defenses really that, okay, they're there theoretically, but they really don't apply that much. Like, they can't be used for something like murder, like it depends on the whole case and all that. What do you think about that?
If I may have examples of the defenses you are saying.
Intoxication.
You see, it's all about capacity.
Right.
Because from capacity is now where you will get mens rea. In that somebody has had an intention to commit an act. So if one does not have capacity, then you cannot be able to prove mens rea. However, you see there are two types of intoxication. There is involuntary and voluntary. Now, assuming you do not drink, but somebody spikes your drink. Now, maybe the way you could have handled yourself without the drink is different from how you are handling yourself with the spiked drink. Now, you cannot really be blamed for actions that have arisen out of the spiked drink. So that is involuntary intoxication. Now, it is very possible for you to claim, I had no capacity to know what I was doing. But there is also voluntary intoxication. A person who is a regular drinker. That is a person maybe who can function with drinking, in that he can have his mental capacities while drinking and can know right and wrong. So that one will not apply. And majorly in any case, you have to look at the elements that have to be proven in any case. So as a defense counsel or as a prosecutor, you are looking at the elements.
Right.
For the prosecutor, you want to prove the elements. For the defense attorney, they want to disapprove the elements, to show that the elements to make the crime are not non-existent as against the accused person. That is how you get them acquitted. So the defenses will come up if at all the accused person is put on his defense and maybe has accepted liability on the crime. Yes. So like let's take for instance an issue of murder,
Okay.
and you are saying about intoxication. One, for me to come to the defense of intoxication, whether voluntary or involuntary, I will have to accept that I killed this person. And now the prosecution has already shown I had intention to kill. Then now I will come in and say, yes, all this is true. However, I did not have the mental capacity to do this crime. At the time of commission of this crime, I was intoxicated with something I did not know. I could not control my actions nor my intentions. So that is how the defenses will come up. I don't know if that makes sense.
Yes, it really does. So to do with intoxication, of course we'll cover the topic in depth in another episode, but there's this case we were doing, it's a hypothetical one, right? So this man had a girlfriend, right? And this girlfriend was going around having an affair with some other person who was a police officer. So one time he is drunk, and he drives by this man's house, the girlfriend's house, and finds the police officer guy leaving. Okay, so he finds the girl standing there and beats her up. She falls down, hits her head in the curb, and she's knocked out. This guy is drunk, tries to wake her up. She's not waking up, so he assumes she's dead. And the police officer helped this guy dump the body in the river, but they did an examination and found out, this girl didn't die from hitting her head on the curb, she died from drowning. So, of course, you've talked about intoxication being involuntary and this person being a regular drinker. The person we have right now is a regular drinker. So could intoxication be used as a defense in this case?
Not really. Not at all. Because these actions were actually, if there was a defense he could claim, was provocation.
Okay.
Because you see, this is my girlfriend, he's coming from another man's house. Yes, the defense could be provocation, but it could not be intoxication because he stopped his car, moved out of his car, came to the lady, who he did not do to any other person, just this particular one, and for a defined or a specific issue he had with her about being a philanderer. Okay. See? So that could not come up. Intoxication is not a good defense for him.
Okay.
But provocation could be, in that it was a heat of a moment issue. Yes.
So more like heat of passion, something like
exactly.
that. Okay.
Yes.
Okay, that's interesting. And this other police officer, could you infer compulsion from that?
Not at all.
How?
Yes, you see, he's a police officer. Then somebody is making a general claim of coming after you. How?
Yeah.
You see, that is a bit out there, and it is not something like there was immediate danger to him. And also there is the aspect now he's a police officer. So he knows more about what the law says, and he could have actually done more to ensure that this crime is reported. He didn't. Now, actually, he is not only an accomplice, but they could be charged both with murder now for the death of that lady.
So there's no way someone could come and say, oh my goodness, judge, reduce the sentence from murder to manslaughter.
No, you see, for manslaughter to apply, it means you did not have intention. Now, how is intention inferred? Intention can be inferred by the actions you have committed, in that if you have hit somebody and he or she has hit a curb, there is a likelihood they could die from it.
Okay.
Now, if they were not dead from the hitting of the curb, then throwing them in a river, really, there could be no other end. If I do not have the ability to swim, I will definitely drown. So there is knowledge from the perpetrators that whatever we are doing will either occasion death or actually lead to death. So with that, manslaughter cannot apply.
But they already thought she was dead.
They are thinking notwithstanding.
Okay.
They are thinking not, it is their acts.
Okay.
Yes. Their acts is what, because if, for example, you take a knife and you stab somebody, it matters not where you have stabbed them. You can stab them on the leg, and fortunately you have hit them on an artery that is leads to profuse bleeding, leading to death.
Yeah.
You see? Now, somebody could argue that I stabbed them on the leg, there was no leading to death, because mostly people say maybe organs on the other side of the body will the ones that are likely to lead to death, right? But even that one, it is still murder.
Okay.
Yes.
Okay, that's quite interesting. Yes, that was the questions that came up. Thank you so much for answering those. Zilitukanganya kidogo. But yeah, thank you again for coming. Thank you for giving us more insight on defenses in criminal matters. And yeah, we really appreciate you.
Thank you for also inviting me, and also for allowing me share a bit of my small knowledge.
Yeah, right, small. Okay. Okay.